I'm here with Patrick Cawley, and he's an elder law attorney in Pennsylvania. First of all, Patrick, thanks for joining me today and taking the time to write this guide for our site and speak with me. Second of all, I was wondering if you could just tell us a little bit more about what you do and what your firm does and sort of how it fits into what we're doing here at Elder Guide.
Well, thanks, Nick. And what Elder Guide does matches up really well with what we try to do with our firm. So, I think Elder Guide recognizes that if an older adult needs long-term care, that adult and their family is not facing a one-dimensional concern. They have, of course, healthcare concerns. They have financial and legal concerns, and they don't even know how to untangle all of those concerns. And so you're presenting information on where the best care can be provided, and now you're providing information on some of the ideas that go into public benefits that are available to pay for that care. We try to do the same thing. My firm is called Keystone Elder Law. It was started by an attorney named Dave Nesbitt and his wife, Marcia. Dave had a very successful career in commercial real estate, but both Dave and Marcia ended up losing all four of their parents to dementia. And reasonably smart and educated people, they were completely confused by the maze of care options, how you pay for the care, what public benefits apply, in what circumstances, estate planning matters. So much like Elder Guide sort of lays it out there that, here might be the best option for you based on available data. Here's some legal information. We do the same thing. And plus we have what is sometimes called in elder law firms across the country, the life care planning model, where we have a registered nurse on staff who used to work in acute and long-term care settings. And she's just an outstanding guide for care options. So that's who we are, and we're trying to accomplish the same comprehensive guiding model that you're doing with your wonderful website.
Our interest in this Medicaid content is really twofold. And one, you hit the nail on the head there. This material, Medicaid, is complex even for non-elder law attorneys to understand, let alone the general public. And two, with nursing home costs being as expensive as they are, up to $10,000 or $15,000 a month, or even more in some areas, the average person going into a nursing home their resources are going to be exhausted fairly quickly. And the data we're seeing is now, upwards of 70% of these people are ending up on Medicaid. So, we felt that it was really a disservice to provide nursing home content without also offering, this Medicaid content to supplement it. And then, also one of the things that's interesting is once you get into Medicaid, it's not this simple one-stop shopping typically in most states where just, okay, you Google Medicaid and you're going to get all of your answers. It seems like states have multiple programs for different types of services. And sometimes there's programs for nursing homes and then waivers for home health care, or even programs for covering some services for people in assisted living. Just wondering, how does that work in Pennsylvania, and what are the different programs? Like, how does that break out?
Right. So first of all, you're right that Medicaid is a lifesaver for an awful lot of families because they get sick. They're told they can't leave the hospital. They're going to need long-term care. And then they find out that Medicare only pays for a very short period of time in a skilled facility. So they scramble to figure out how are they not going to blow their entire life savings on the long-term care, because nobody is disciplined about their savings and spending for their whole life only to have it go completely down the tubes in the last few years of their life because of healthcare. So Medicaid planning is very important. In Pennsylvania, Medicaid is technically called medical assistance. Every state implements the federal Medicaid program, and they often have different names for it. So medical assistance in Pennsylvania applies to the highest level of care. So skilled nursing care, where you're in a facility, you're getting either nursing care, you're getting occupational therapy, physical therapy, other types of skilled care. The middle level of care would be something like assisted living, or in Pennsylvania, more commonly, it's called a personal care residence. That's a distinction that people don't really need to understand. It's more a regulatory language issue, and practically there's not much of a difference. But for the most part, Medicaid or medical assistance in Pennsylvania does not pay for that level of care. The lowest level is care that would be provided in the home by a home care agency or a skilled home health agency that would send nurses to the home. That, again, Medicaid is not going to pay for it, but that's where there's some room for what is often called in elder law circles a waiver program. What is being waived is the normal requirement that Medicaid is paying for care in a skilled facility. So the idea is, and I'll just highlight one alternative that's a waiver program in Pennsylvania that people might want to check out, and it's called the LIFE program. LIFE stands for Living Independence for the Elderly, and it's so you stay in your home, which is really what everybody wants. I've yet to meet a person who says, I really want to move to a nursing facility. They want to stay at home. And what the LIFE program does is, even if you're medically eligible for whatever reason with your condition to go into a skilled nursing facility, if it's safe for you to stay in your home, so, maybe not for somebody who has dementia and is prone to wandering or something like that, but if you can stay there and have health care brought to you, the LIFE program will either provide that care that you need in the home, or more commonly, they will transport you to a local center, and they're throughout the state. And at that center, it's a one-stop shop for every type of healthcare service that you could need. And again, this is the same as if you had Medicaid in a skilled nursing facility. It's all paid for. And you go and you get your doctor visit, you get your eyes checked, your dental needs, any sort of physical therapy. Plus there's socialization with other people and, the kind of stimulation that avoids the health detriment of isolation. So the LIFE program is great for people who are safe to stay in their home and want to stay in their home and still have that medical eligibility for Medicaid. So that's a Medicaid-like situation in Pennsylvania, but we're not like states like Florida that have multiple levels of Medicaid, that even apply in assisted living. Unfortunately, the $10,000 to $15,000 range for skilled nursing facility, that can be avoided with Medicaid planning with an elder law attorney. The assisted living, you're a little more hard pressed to find government benefits. Maybe if you have veterans benefits or something of that nature, but you're looking at probably $4,500 a month there.
It's interesting because that home health care route really seems to be the direction everything is moving in right now, and it seems to be for a combination of reasons. First of all, like you said, very few people actually want to go into any type of senior living. Most people would rather stay in their home if they can, but it's just a question of whether it's safe. And then at some point, a person needs so much care that not only is it unsafe, but if it's 24/7 home health care, it's actually going to be even more expensive typically than a nursing home. So it becomes totally impractical. But for a typical person, that only requires a few hours a day of additional supplemental care, and then maybe has a family member that helps out. Those can be great options. And I think the states are finding that it's also economically a lot better for the states to pay for that than to end up with a person going into a nursing home, perhaps at 2 or 3 times the cost. You also have COVID, I think, which is, concerns about that and not wanting to be in a nursing home are also pushing things in that direction. But I don't think that that's something that's going to change in the near future. I think we'll see more and more of those programs popping up around the country.
You're absolutely right. It's good for the people who need the care. It's good for the governments paying for the care. It's good for everybody. And there's long been talk in Pennsylvania in the state legislature about expanding funding and support for community-based care as opposed to facility-based care for just those reasons. But yeah, COVID certainly put a damper on that conversation. But I still tend to think like you do, that will be more encouraged in the future. I mean, just with the graying of America, the baby boom generation growing, fewer people to provide the care, I think we're going to need to do more in the community than we do in facilities.
Right. So I wanted to go into, at this point, the qualification process. So I know we've got this income test and an asset test. I want to start with the income test. And obviously a state has an income limit, and then the most common scenario, obviously, that you require planning for there is just simply somebody that makes a little bit more money than whatever the monthly limit is. Can you walk me through, that process and how that works, and what do you do if you're in that boat?
Sure. And states deal with this differently as well. So there are states where it's a hard cap on income, and other states deal with it differently. In Pennsylvania, generally, the person who is going into a skilled nursing facility on Medicaid may have as much income as they can have up to the cost of care. As you might imagine, That's pretty rare that somebody would have income of, $10, $12, $14,000 a month. So most of the time, that's not a problem. Their level of income is whatever their level of income is. And it's much more a concern about how much are your assets. So how much do you have sitting in bank accounts? How much is your, investments, retirement accounts, and things like that. And we can talk about the assets separately, but any Medicaid planning situation deals with income and assets. And as far as the income goes, the person in care, they can't have more than the cost of care. If there's a spouse, let's say a healthy spouse staying at home while the other spouse goes into a nursing home, that person can technically have as much income as they want. So there's no ceiling on the community spouse, as we call them, on their income, but there is a floor. And this is a matter of federal law. So it's called the MIMNA. You'll hear that term with elder law attorneys, and it stands for the monthly maintenance allowance, monthly maintenance needs allowance. And so what that means is the caveat on having, income for the person going into care is that their income goes to the nursing facility, and then Medicaid picks up the rest up to whatever it costs for that person every month. So if, let's say they have a pension or Social Security, so it totals about $1,800 or $2,000 a month. That's the person going into care. That goes to the nursing facility, and then the thousands of dollars above that every month is covered by Medicaid. Meanwhile, the person who's in the community, the spouse in the community, if you look at their income, mainly because our lawmakers don't want, let's say, the breadwinner to go into a nursing facility and then have the spouse at home be impoverished simply because their spouse needed long-term care. So what you do is you look and you say, well, how high or low is that person's income? And if it's low, then the MIMNA means that instead of transferring the spouse going into care, their income to the facility, you transfer it over to the spouse to keep them at least a minimum level so that they can get by. So that's sort of the high points of what we talk about when we talk about income, whether there's a MIMNA going to the spouse who's in the community, how much of it is going to the nursing facility as opposed to that spouse, and so forth.
Right. And that brings me actually to my next question, which is, there's seems to be typically this asymmetry in terms of how this planning works, depending on whether a person is single or married when they're going into a nursing home. The asset test, I think, is a little bit more strict than the income test in most states. I believe in Pennsylvania, you have to be under $2,400 in countable assets. How does that play out for a married couple versus a single person?
Sure. And you're right for the most part that we can assume that somebody going into care can't have more than about $2,400. Really, if they have a pretty low income, that will trigger a provision where the state sort of ignores a certain amount of money so that they can have as much as $8,000 in income. But let's just assume between $2,400 or $8,000. So if a married couple were to come into my office and let's say they have $300,000 when you count up all of their countable assets, what do we do about that? Because, with this, let's say, $2,400 limit on the person going into care. And the way it works is the first thing we do is we imagine a box and we put all of their assets, whether they are owned by the spouse going into care, owned by the spouse who's not going into care, or owned jointly. Let's assume we're going to put it all into this box and add up the value of everything, and then we'll have a total amount. Well, before we do that, does everything go in? Pretty much the answer is yes. So what doesn't go into the box to be added up would be certain non-countable assets. So in the eyes of Medicaid, it's just not going to be part of the evaluation of their estate. So they're allowed to have one car. And it doesn't even matter if the person going into care is going to be driving the car, or if anybody's going to be, could be a child who's a caregiver might be driving the car, but they're allowed to have one. If they have more than one, well, it depends on the circumstance, but very often what you'll do is you'll say, well, the more expensive of the two is going to be the non-countable asset, and we'll, in order to keep the resources low in the box, we'll put the less expensive car in there. So that's the car. They're allowed to have if it's their primary residence, and especially if there's a spouse still living in it, and if the person going into care, if they're single, intends to return to the home, that is not a countable asset. So for eligibility purposes, you don't have to worry about having a $300,000 home. That's not going to put you way over the $2,400 asset limit. That's just not countable. We can get to other aspects of the house and how you want to, because people are always worried they're going to lose their house. Well, it's not at the eligibility point they need to worry about that.
Right.
That's not a countable asset. So so in Pennsylvania, the only other thing that comes to mind is IRAs, retirement accounts. So typically our clients are at a point where they're old enough to be taking required minimum distributions, and they've had these accounts for a long time. The way it generally works is the spouse going into care, that is a countable resource, and very often it's assumed we're going to have to liquidate that account, cash it in, maybe have some tax penalty depending on where they are in the scheme of things, and that money goes into the box. The IRA of the spouse who's healthy and not going into care is untouched. That's non-countable. So that's generally but everything else goes in. We add up the total amount and then essentially cut it in half to get what's called the community spouse resource allowance. This is only for married couples do we do this. We don't do this whole analysis with single people, to answer your question from the beginning. So for the community spouse resource allowance, you've counted up the value of everything in the box, you split it in half. Half of that amount stays protected from the outset. Again, this is part of the concern that we don't want a healthy spouse to be impoverished simply because the other one needed long-term care. So half of it is saved right off the bat. The other half, let's say if they had $300,000 in countable assets, $150,000 is what we have to bring down to $2,400. So how do we do that? That's what Medicaid planning is all about, and we can talk about different strategies to do that. But that's how you first go about analyzing assets for a married couple. For a single person, it's pretty much everything, including their IRA. It's just the house, then the car that gets set aside.
Right. So it seems like it's a two-step process of first figuring out what's countable and what isn't, and then secondly, I guess the question is, what can we do? After we allocate the CSRA to the community spouse, whatever assets are left over, what can we do from a planning perspective? One of the concepts I think is interesting is sort of this idea of repositioning, your assets, and the fact that there's this distinction between countable versus non-countable assets. I mean, it seems like there must be quite a few strategies that simply involve taking, if you have something like cash or stocks or something, just simply using those to acquire things that are non-countable. Like, if the equity in the house doesn't count and the house needs a new roof, I mean, that's the time to do it because you're going to lose that cash anyway.
Right. Yeah, you're absolutely right. So that's how it starts is, in a sense, if you have debts, you can just simply pay off the debt. In that sense, you're kind of accelerating something that will have to be done eventually to right now as part of your spend down strategy. So that one half of the countable assets that has to be spent down to $2,400, put a new roof on the house if it needs it. Maybe the spouse who's staying there is also getting older, could use some modifications to the house to make it better for aging in place for that person. So, putting in ramps or grab bars in the bathrooms and things like that. You can, I think you mentioned, buying something that is a non-countable asset. So putting money into a reserved account for prepaid funeral planning or burial expenses, you can do that, and that's not considered holding money that could otherwise be used for your care. Sometimes people even talk about having caregiver agreements with a friend or a child, one of their children, where you have a whole agreement about that you're going to compensate them because you need to spend the money, and you might need care provided beyond what is provided in the nursing home, even if it's just running errands, or there's certain things that are allowed and certain things that are not allowed. But there are services that can be provided by a friend or family member as long as you compensate them. that gets a little weird with the conversation because many children will say, well, you're not going to pay me to take care of my parent. That's what we do. And I get that, but you have to convince them this is actually very good in order to get Medicaid for your parent. So there's some pluses and minuses of doing the caregiver agreement, but that's another option to spend down money. Legal fees to get the advice to navigate all of this can be deducted as an expense. So there's a number of ways to do spend down. And ultimately, if you just can't cover the distance between, let's say we cut it into 150 and 150 and we have to get one side down to 2,400, if you just can't get down to 2,400 with this kind of spend down techniques, we usually cover the remaining distance by turning assets, which we've talked about, into income, which we've talked about. So let's say, since we already discussed how the community spouse, the person who's not going into care, can have a lot of income and it's not going to affect the eligibility of the spouse going into care, well, we can take excess assets and buy an annuity that immediately starts paying back a check once a month for a certain period of time. And that money goes to the community spouse as income, which they're allowed to have. So you've turned an asset you're not allowed to have into income, which you are allowed to have. And this is the point in the conversation where people look at us and they say, is this legal? And it is. I assure you, this is written right into the law. This is, the Medicaid officials themselves will tell you this is an acceptable strategy.
Right. Well, and that's interesting. I mean, it does seem like, two of the things that pop up if you start, searching for, Medicaid information are always going to be this notion of gifting and annuities. And I think a lot of people have actually heard of those two concepts independently. And, what are some of the pitfalls to somebody that's trying to employ one of those strategies on their own versus contacting a elder law attorney and making sure that they're complying with all of these rules?
Right. Well, a lot of people don't even know that gifting is a complex and problematic issue when it comes to needing long-term care. So when you apply for Medicaid and we put together an application, we send people on a paper chase from the beginning. So we need 5 years of bank statements. We need 5 years of tax records, and we're going to go line by line through them just because we know that the Medicaid agency officials will do the same thing. And what we're looking for is transfers of money. If you transfer money to another person in the 5-year period before you apply for Medicaid, then that's treated as a gift. It's a transfer for less than fair market value. So, whether people know it or not, they're giving money for, a wedding gift, or they're giving it for this reason or that reason. And you can't simply say to the Medicaid people, well, I didn't do this so I could qualify for Medicaid, because if it were that easy, everybody would do that. So although it's true, it's just very hard to prove. So if you give a birthday gift or a Christmas gift every year in the same amount to the same people, then, an argument can be made to the Medicaid agency that this was obviously a regular and persistent gift. They weren't doing it to draw their resources down and become eligible for Medicaid. And normally the response is, we get it, we'll overlook that one. But for the most part, gifting is problematic. We have to look back 5 years. In Pennsylvania, as long as the gifting in a given month is under about $500, we're okay. But if we start seeing $700 in a month, if we start seeing, more than that in a month, large gifts, that all has to be added up, and it results in a penalty period. And what the penalty period means is there's a way we calculate it based on the average cost of care per day. So that, and then how much you gave away, and you use those two numbers to figure out how many days of private pay at that $10,000, $12,000 a month rate you're going to have to pay before Medicaid will start paying. So gifting is to be looked at very, very cautiously if you think that long-term care might be in your future. Now, all that being said, gifting is also part of our spend down strategy. So again, if we, not to make you totally confused, but if we get to that point where we just can't spend down your money to the eligibility point of $2,400 in assets, and I talked about the annuity is usually done, it's sometimes called the half a loaf strategy. There's other names for it, but what we'll do is make a gift, and that's keeping money. Remember, the whole goal here is to keep as much money in the family as possible, especially if the spouse in the community might need care eventually themselves. So we make a gift of that money, knowing that we're drawing a penalty that I just described, but then the annuity payments that come in month after month will cover the cost of your care at the high private pay rate for the length of the penalty. And so that's how one takes care of the other. So the gifting and the annuity strategies work together. But I would really prefer if people leave that to us as a carefully thought out plan, as opposed to just giving away their money and thinking, whether it's because they don't know better or because they think they're being clever and they give away a house for $500. That's a gift, and a substantial one that will result in a penalty.
Right. I mean, my guess is probably the two most common mistakes people are making is one, gifting without any professional advice and probably not employing it in a sound way. And then two, my guess is many of those people, when they fill out that Medicaid application, are also making mistakes in terms of what they're reporting and disclosing, and you can get in a lot of trouble for that as well.
Absolutely. There's criminal penalties for
Right.
not doing that right. So and there we're talking about, well, they'll never know about this gift, or, I was clever about how I did it. They will know, because
Right.
they're searching high and low in your records, and you don't want to get caught with Medicaid fraud. Every state actually has, and usually in their state attorney general's office, has a Medicaid fraud control section. That's the language under the federal law. And so they will find you, and you don't want them to find you. So
No.
don't try to hide assets.
Yeah, and another overarching theme here is, I think, a misconception, not about Medicaid planning strategy, but just about the concept itself is, I think some people think, that in doing this, you're trying to get away with something in order to qualify for Medicaid sooner. But my sense is, in most cases, preserving assets, you're really just acting in your own and your family's best interest, because in addition to trying to possibly preserve some assets for your spouse or even your children, as you mentioned earlier, Medicaid doesn't cover everything. And so, just because you qualify for Medicaid, if you don't have any other assets, you might not be receiving the best care. And perhaps, an extra few $1,000s could make a significant difference in the quality of care you're receiving, if you can afford to buy some additional care you need, or buy an additional piece of medical equipment that's not covered. A lot of people are overlooking that side of this as well.
Absolutely. And I mean, if we're talking about whether this is, people can quibble about whether this policy makes sense, that this is really the safety net for the middle class. Many people thought that the rise of long-term care insurance would be the solution to this crushing expense that will wipe out the savings of many middle-class families. But it kind of fizzled out as unworkable, and just really hasn't been the answer. And Medicaid continues to be the answer for families. So, we can talk about whether it's the right policy, but if you think about very similarly situated neighbors on the same street, one person could, have a heart attack and go into the hospital and need heart surgery and be in the hospital for, a few weeks, and then maybe need a short rehab stay to rehab from that experience. And Medicare will pay for the whole thing. But then if the neighbor gets dementia and needs to go into a nursing home for a long period of time, that person's going to have to spend their life savings. So, and then there could be the person on the next street over who just, because of lifestyle choices with food or alcohol or whatever it might be, they just never saved any money at all. Well, the government's just going to pay for everything for them because they have no money. And so they become qualified for Medicaid right away. So why would that middle one, be penalized for doing what they do, what everybody does with tax planning, going to a professional who can say, well, the law says you're allowed to do the following to keep from paying too much, so that's what we're going to do. I mean, Medicaid planning is about following what the law allows, and the law allows that, this Medicaid planning, because there are other circumstances where people are having completely different treatment as far as our healthcare system goes. So I'm not saying it's perfect, but it is what the law allows, and there are awfully good arguments for it.
Oh, absolutely. Absolutely. Another, buzzword that comes up is trusts, and there's a multitude of different types of trusts. My understanding is, none of them are really a magic bullet here when it comes to Medicaid planning. But there's other aspects involved there as well. One of which is testamentary trusts, and the idea of, in particular, where you have a spouse and some of the estate planning aspects that come up with, with protecting assets, particularly in the event that that community spouse were to pass away first. I mean, what are some of the considerations there, and where do trusts fit into this picture?
I'm really glad that you brought up estate planning in general and trusts in particular. So let's just start from a broad view on estate planning. The most important thing that anybody who might have long-term care in their future, which is a lot of people, 70% of people over the age of 65 are looking at some duration and form of long-term care. It all starts with your estate planning, and your estate plan should include either a will or a trust, and we can talk about the differences there as you just asked. But the other two pieces are a financial power of attorney and a healthcare power of attorney, sometimes called an advanced healthcare directive. All three of those play an independent and extremely important role in planning for the future, even if there is no long-term care. But the financial power of attorney might be the most important. That's one of the first things I look at, because remember all those strategies we just talked about, especially if we're making a gift, especially if we're buying an annuity, signing agreements for care. If the person who needs care is incapacitated, which is very often the case, they need somebody else to do that, all of those legal and financial decisions for them. That's where the financial power of attorney comes in. If they don't have one, the alternative is having to go to court for a guardianship, and that's expensive. It's cumbersome. There's time spent in court. Then there's reporting requirements to the state. So I can't emphasize enough that if anybody is watching this, they should ask themselves whether they have a complete estate plan, a will or a trust, a financial power of attorney, and a healthcare power of attorney. And they should really have one prepared because it's just very important for a lot of reasons. To answer your question about, the different kinds of trusts. So, often people will ask me, I spoke to my friend in Florida or my friend in California, and they said I shouldn't have a will, I should have a trust. And usually what that person's referring to is a revocable living trust. And it's one kind of alternative to a will. Usually, and if you were to even Google will versus a trust, you'll come up with these top 10 reasons to have a trust instead of a will. Probate avoidance always comes up on that list. And frankly, in states like Florida and California, probate is to be avoided because it's expensive. The fees you pay to the court when you just to even open an estate, it takes a very long time to settle a person's estate. So setting up revocable living trusts is very common because it's a private agreement and it gets administered privately without having to go to court. So there's a very valid reason to have a revocable living trust. In Pennsylvania, the fees are very reasonable. So if you have something like $1 million estate, the fee to open probate costs like $600, which is not nothing, but it's in the scheme of things, that's fairly reasonable. Estates can be settled in a little over a year, and that's because there are built-in timeframes for notifying creditors that an estate has been opened and filing an inheritance tax and things like that. But it's speedy, it's not all that expensive. So if that's your only concern, a revocable living trust gives you no advantages for probate avoidance. It's just not really a reason to do it. But the more important question for purposes of Elder Guide is what kind of a trust do you need for Medicaid planning? A revocable living trust gives you no advantages for Medicaid planning because if the whole idea is to say wall off assets and say, well, it's in the trust, it's not my money, it's the trust money, therefore I should qualify for Medicaid. That's not the case with a revocable living trust. Those are all, anything in that trust is considered accessible by you because you are the trustee while you're alive. You control the money and therefore you can pay for your own care. However, some people choose to plan way ahead and set up an irrevocable trust, which is one where you are literally giving your money away. And that's a point that has to be emphasized for a lot of people because you're putting it in this trust and you're not the trustee, and distributions of the money are solely at the discretion of whoever that trustee is. So even if it's your child, and life will go on as normal, that, your bills will get paid and so forth, you're not the one making the call about when money gets spent or how it gets spent. So that giving up control is difficult for a lot of people to wrap their heads around. But the upside of it is that when it comes time to apply for Medicaid, you can truly say, I gave all my money to that trust. I don't have anything. Therefore, sign me up for Medicaid. one cautionary note is that's treated as a transfer, just like a gift is. So you have a little bit of a gamble that you're going to go 5 years and not need Medicaid because, you give that money away. That's a sizable transfer of money that would result in a penalty. As long as you make it 5 years without needing long-term care, you're in the clear. And that's a great planning strategy. For a lot of people, it's, because of their age or the medical condition they're in by the time we have this conversation, it's just not an option. But that is one planning option.
Right. You touched on a few interesting points there, one of which was you're talking about power of attorneys and any of these plans, whether it involves strategies of, gifting or repositioning assets or implementing these trusts, you have to plan for the possibility of incapacity for yourself. Obviously, I think that's probably one of these forms that people are most likely to have an internet form or something that probably doesn't meet the standards that are necessary, at least to do this kind of sophisticated planning that's necessary in the Medicaid context. But also, when you're talking about incapacity, there's the possibility of someone else in your family having issues or, being disabled. I just want to touch quickly on special needs trusts and how they fit in. I know they're not necessarily directly part of Medicaid planning, but they can certainly be relevant to somebody who has a disabled spouse or child. How do they fit into the bigger picture of this Medicaid planning strategy?
Yeah, that's a great question because one, we've talked about already transfers from one person to another of assets in order to spend down assets and become eligible at that $2,400 asset level. So one thing I didn't note is that assets can be transferred to a spouse. So you can transfer certain amounts of money, or you can retitle an account or retitle a house into the name of the spouse, and that does not draw a penalty. The same is true of a disabled child who happens to be living in the house. So, or not living in the house. I mean, you can give to one of your children who is disabled certain property, and so that's one aspect of where people with disabilities comes into the picture of Medicaid planning. Even if you are leaving money in a will, though, or in a trust to a disabled person, that person might likely need Medicaid as well. So Medicaid planning is very much a reality for, let's say, disabled children with special needs. And that's a whole area where you need to talk to an elder law attorney who understands special needs, because it's a landmine where you can easily make mistakes,
Right.
especially when you consider children who are, say, born with Down syndrome or have autism, or somebody who's relatively young who is in a car accident and has a traumatic brain injury. They're going to have money to sustain them for a very long time. The life expectancy for even people with Down syndrome has grown significantly over the years. So who's going to sustain them if they're never going to hold a job that comes with medical benefits or has a nice amount of income to pay for an apartment or something like that? So even just as a part of your estate planning or Medicaid planning, you have to consider their Medicaid planning and their Social Security benefits, because giving any amount of money directly to a person with special needs will have a direct negative impact on the benefits that they might require to survive. So that's a very, so special needs trusts are generally how you do it. You don't give money directly to a person with special needs who needs SSI or who needs Medicaid. What you do is you give it indirectly to a trustee, and that trustee decides how to distribute the money to the special needs person. And there are other tools like ABLE accounts, which were only created in the last 5 years nationwide, and states are more and more implementing them. But they're a wonderful tool. Even if it's just to pay for food and shelter, which normally would cause a direct reduction in benefits. If you do it through the ABLE account, it's non-taxable and it doesn't affect public benefits like SSI and Medicaid. So anytime a person with a disability comes into the picture, I hate to say it's complicated, call me, but it is a landmine where you don't want to give money direct. If there's one takeaway, it's don't give money directly to that person. Either put money into their ABLE account, set one up for them if they don't have it, put money into their special needs trust, and then have it go indirectly to them, but don't give money directly to them, because that will reduce their eligibility for Medicaid and their Social Security benefits.
Yeah, and we've talked about a number of these intersections between Medicaid planning and estate planning and Medicaid planning and planning for incapacity or disability. Another one I wanted to just cover quickly is the notion of estate recovery. And every state has a system in place where, if they cover your long-term care costs, after you might be able to qualify for that coverage, but then after you pass away, the states will go after certain assets that you own and try to recoup those to reimburse themselves for the costs that they covered. So one element is of Medicaid planning, in my view, is always qualification. You want to do that as early as possible. But the best planning, ideally permanently protects these assets and shields them from estate recovery as well. How does estate recovery work in Pennsylvania? What types of assets are they going after? And how do some of these planning strategies we've discussed fit into that picture?
Great question. And yet you're right. We don't just get the person in the door of the nursing home and then call it a day. We think long term. So you're right that federal law requires every state agency that administers Medicaid to go into an estate recovery action to recoup the costs of Medicaid. Now, how the states do that varies from state to state. So some states have something called enhanced estate recovery, where it's hard to protect any assets from that repayment to the government down the road. Pennsylvania is not one of those states. So they're going after probate assets. So they've paid for your care, they've paid for your loved one's care, and they don't try to recoup the money until after the loved one has passed away. At that point, they know how much was paid in care. They're going to look for probate assets, which means that an estate has been opened in the county courthouse. Some sort of notice has been published as part of our probate process that it goes up like a flare to all creditors and says, if you have any claim against this person who is now deceased, now's the time to step up and assert your claim, and we'll figure out how to pay you out of the available resources. So that's as soon as that happens, Medicaid gets in line and they say, we paid all this money for care. Now, that's only for probate. So what doesn't go through probate? Well, if you have a trust, it doesn't go through probate. Your estate gets administered privately, so there is no estate recovery. Another thing we do, though, so what would be probate property? Anything titled in that person's name. So in a bank account, anything, if their name is on the title of a house, that could be probate property that could be subject to estate recovery. So that number one question that people seem to ask when they come in for their first meeting with us is, I don't want to lose my house. How do we avoid losing the house? The house is not the problem when you get eligible, as you said, that first step process of just getting eligible. The value of the house doesn't put you over the eligibility limit as far as limited assets. But you need to worry about the house in terms of estate recovery down the road. So for married couples, it's a lot easier than it is with single people. Often what we'll do is transfer the deed of the house from husband and wife jointly to just husband if wife is going into care. So that way, it doesn't make a difference for eligibility because that's not a non-countable asset. But down the road, once wife goes through her care and eventually passes away, Medicaid's going to show up. But if they don't see a house in her name, they're not coming after it. So that's one way to avoid estate recovery. That's the most common way to avoid losing the house, as people tend to say it. So, and this also comes up for, since you mentioned special needs people with disabilities, there is a certain kind of trust. So imagine somebody who has a birth injury and they have, some sort of lifelong problem that they have to live with, a disability that resulted from a personal injury, essentially, and they get a settlement. That's their money. But the deal with the government is the government will pay them Social Security and Medicaid so that they have money for food and shelter and health care. But the deal is you're going to hold that in a certain kind of first party trust. It's that child's money for the rest of their life to sustain them. But the deal is there's a payback provision. So the same concept comes into play with special needs law, where there's an estate recovery component to it. And there are ways to plan for these things, but that's definitely something to keep in mind. And another thing, not only transferring the house for when the wife goes into care and the husband is not in care, transferring the house to the husband, but one other thing that you asked about that I don't think I answered earlier, which was, what about testamentary trusts, where you have a will-based estate plan? So it's headed for probate, that still is important, because after we jump through all these hoops of getting somebody eligible and moving assets and drawing down assets, if say wife has gone through that whole process and is getting the care she needs, and then husband, who was healthy in the community, passes away, if his will just says, I leave everything to my loving wife, and her will says, I leave everything to my loving husband, that's a problem, because everything that he owns is now putting her way over that asset limit of $2,400, and that blows her Medicaid, and now they're back to square one. Everything will have to be spent on the cost of her care. So you build in trusts so that everything does not go directly to loving wife. It goes into a trust for loving wife. And as you said, you can pay for certain things to enhance that person's quality of life without disrupting the benefits.
Yeah. And, we keep coming back to this issue of, the one, obviously, it's relatively complicated, but there's also, there's so many layers of this planning. When you start peeling away, the onion here, you realize that you really need somebody to be keeping an eye on all of these issues, because there's just so many areas here where you could make a mistake.
It's not a matter of picking up an application and writing your contact information. It's much more complicated.
Yeah. This is not something I can picture the average, particularly the average person going through this phase of life. And obviously if you're looking at going to a nursing home, you're suffering from some kind of medical condition and under probably quite a bit of stress, your family as well. You just want to make sure you sort of, measure twice and cut once here, and have your eye on all these ancillary issues out there. Another thing I just wanted to touch on, and I think this is probably a little bit of misinformation as well. You hear all the time, but you constantly hear people saying things like, if I'm on Medicaid, I'm not going to get into the nicer facilities, or if I'm already in a facility and I switch to Medicaid, they're gonna throw me out and I'm gonna have to move. And sort of talking about some of the other drawbacks of being on Medicaid. I mean, how much of this is actually misinformation? And I mean, is there any truth to any of this?
Well, I've heard those same things, and I've heard, people call facilities and they're told, oh, we don't have any Medicaid beds left. There's no such thing as a Medicaid bed or a private pay bed, except in the minds of the people who are the administrators of the skilled nursing facilities. And I don't want to say that I'm judging them negatively, because I wouldn't want their job where, they get paid a lot more if somebody is paying privately than if they're on Medicaid. And that's sort of on the state legislatures that don't increase the reimbursement rate for Medicaid. But right now it's significantly less that they get paid if the person's on Medicaid. So that's what you're talking about, where people fear that because the facility is getting less money because it's Medicaid, that's going to have some consequence for them. Let's start with just, on the unit where they're living. The staff people who are their caregivers have no idea how you're paying for your care. So it's not going to result in any sort of direct effect on the quality of your care. If you could demonstrate that it did, they would be subject to, sort of career-ending legal consequences. I mean, the facility would be in a lot of trouble if they somehow provided different levels of care. It is unlawful to discriminate based on the source of payment. So technically, they're not even supposed to stop people at the door if they are on Medicaid as opposed to private pay. Now, practically, if you arrive at a skilled nursing facility because you had a trip to the hospital and maybe you had surgery and now you need to have some physical therapy as part of your rehab program, and then it turns into a long-term stay, well, you will be welcomed with open arms because Medicare pays at a pretty high rate. It pays for everything that you're going to need. And then if you then see Medicare ending and you switch over to Medicaid, they're not going to kick you out because that's against the law. They can't kick you out. Some people, if you don't go straight in on Medicare or straight from a hospital, that's how that works. It helps to have some private pay money so that you go in, especially if you want one of the nicer facilities, you go in and you pay, while your Medicaid application is being prepared, you're at a private pay rate, but that can be a relatively short period of time. These are all situations where it helps to talk about it as far in advance as you can. It's not always foreseeable, but if it is foreseeable because of a diagnosis that's progressive and is moving along, then I would recommend planning it out how your approach will be to get into the right facility, which brings in, the concept of continuing care retirement communities where you can even start in a place that's independent living. It's like having a condo, and then as your care needs escalate, so does the level of care in the same facility or the same campus that you might be on. So there's a number of different options, and the longer in advance you talk about those things, the better. But how you pay for the care should not make a difference in whether you're admitted. Certainly, you're not going to get kicked out because of a change in how you pay for it.
Yeah, and just to touch on what you said about being able to pay for a few months while your application's pending, my guess is regardless of what the law says on this, some of these places have waiting lists, and there's probably not much transparency as to who they select off those waiting lists. So I'm sure there's something going on there where you're probably a little bit better off if you can at least upon admission cover those first few months. But I think overall, my takeaway there from what you said is just that most of this is really, a myth about the disadvantages associated with Medicaid.
Yeah, I'm not saying that I haven't heard those things or heard that people speak to people at nursing facilities and they're told about some difference between a Medicaid bed and a private pay bed. It happens, and sometimes it's just simply misinformation to the staff of the facilities themselves. But in reality, especially if you have an elder law attorney in your corner, that's not going to be something that you encounter. There's no reason for fear there.
And so just to wrap up here, we covered a lot here. This is great information, but, what are, just for people watching this, what are some of the common checkpoints that people are going to pass through here, as they're aging or receiving a diagnosis? I think one of the more difficult things is just sort of knowing, when to pick up the phone and call an elder law attorney. I think everybody, or most people anyway, when they're in this situation where they're literally knocking on the door of a nursing home, are realizing that they wish they did some planning. What are some, sort of warning signs that, maybe you want to start this process?
Well, the warning sign is turning 18. And at that point, everybody really should have an estate plan, and to include a will or a trust and and the two kinds of powers of attorney. Realistically, most people find other ways to spend their money, or it doesn't even have to be expensive, but a little bit of careful planning that goes beyond what you can find on the internet is going to save you so much more expense and hardship down the road. So, you mentioned earlier what solutions available online. I have yet to see one of those, and some of them are better than others. One a client brought in was what they got for $19.99 on the internet, and it had none of the provisions that Pennsylvania law says must appear somewhere, let alone the creative thinking about, well, how do we set this up to avoid problems with Medicaid down the road? So even if you go to an estate planning attorney, some of them want nothing to do with Medicaid planning because they want really high net worth people who can write a check for $150,000 every single year that they need long-term care. So, they want to play with really large amounts of money and complex tax planning. Elder law attorneys, the sooner they're involved, the better. And it all starts with good estate planning. So having a really solid financial power of attorney, having, the younger you are, maybe the less likely we're going to worry about asset protection in your will or a trust. But at some point, especially if you have a family history that you need to pay attention to, a medical history of dementia or Parkinson's could become a reality for some people. But if you get a diagnosis like that, certainly that's a wake-up call that there's some planning to do, not only in terms of the healthcare needs that you will have and having somebody like a care coordinator at an elder law firm guide you through that, but also just start, before you're in that 5-year window where you can't move money without facing a possible penalty, a private pay penalty. These are just all examples of why the sooner the better. But the reality is, yes, some people put it off. They have a trip to the hospital that they didn't expect, and they have to go to a skilled nursing facility. And that's, we call that crisis planning, and we'll get people through it. But it sure is easier financially, emotionally, and better for their health probably to plan far in advance.
Right. Yeah. And one of the things you touched on there was, people with some type of dementia, everything I'm reading is saying that Alzheimer's is one of the fastest growing diagnoses, that people are getting in terms of a severe long-term, health ramifications. That's a disease where I think the average person, it plays out over like 8 to 10 years. And certainly, with some other diagnoses, I mean, you don't have much time to plan, unfortunately, with different types of cancers and things like that. But if you're getting a diagnosis where, you have a 8 or 10 year window, you certainly, and in the beginning of it, you might not need any care at all. And you might be perfect, relatively lucid, but you don't want to wait until it's too late to start this planning. That's sort of the one issue that I think is becoming more and more of an issue these days.
Absolutely. You're right. I've seen the statistics on Alzheimer's, which is really just one of many, many kinds of dementia. And the numbers are just skyrocketing. And whatever the reason may be, it is a cause for alarm. I mean, the aging population in general is getting larger, especially in proportion to the younger people who are going to be the care providers. But as the aging population grows, those numbers of dementia will continue to go up. If you get a diagnosis of mild cognitive impairment, which is really another way of talking about early dementia, you don't want to take the gamble that that's not going to progress over time and get worse into something else.
Yeah.
That's the time to start making legal planning. And it's the kind of thing that most people get that diagnosis and they don't think of a lawyer or legal planning. They're focused understandably on their health care. But hopefully through your efforts to educate people and the wonderful resources and information you're making available, it will dawn on people that this is very much an aspect, one of the many tangled up issues that they have that elder law attorneys can be very helpful with.
Yeah, I hope so. And thanks for your kind words there. And thanks especially, Patrick, for taking the time to do this and draft the guide for our site and speak with me today. This is just great information that I'm confident our users will find to be very helpful. We really appreciate it.
Oh, it's my pleasure. And thank you for putting that site together. It's going to be a wonderful resource for an awful lot of people. Hopefully life-changing information for them.
I hope so. Thanks, Patrick. Take care.
You too.